Welcome to Rise Up in Business, the law podcast for small business owners. I'm your host, Tracy Milacrane. I'm a business lawyer, an entrepreneur, and very much a realist. Rise Up in Business is designed to share with small business owners important legal information and some clever tips and tricks in short and sharp episodes, no legal jargon. With this podcast, I want to empower small business owners to rise up and take control in their business. I'll be here every Wednesday to tell you what you need to know without sending you to sleep. Let's get into today's episode. Hello everyone, and welcome to episode 28 of the Rise Up in Business podcast. I'm so happy to have you back and listening to my little tips and tricks and pieces of guidance that I offer for business owners. And I really hope that you're getting some value out of these episodes and that you're finding what I say really easy to understand and apply in your business. So today I want to talk about a topic that seems to be increasingly conversational or increasingly topical, if you like, in the small business world, and that is the topic of trademarks. I'm hearing a lot at the moment about trademarks and people under the false impression that everything needs to be trademarked and it needs to be trademarked immediately. Trademark, trademark, trademark. And there are certainly occasions where a trademark application really is appropriate. But that's not for everybody, and that's not all circumstances. So I wanted to spend today's episode talking a little bit about trademarks and my thoughts and tips and tricks on the decision-making process for you when you're thinking about whether to apply or not to apply. First of all, I wanted to touch on initially the right to exclusive use of certain names or phrases. So what I mean by that is your exclusive use of the right to use a name or a phrase in your business. Business names and taglines are the two most common things business owners try to trademark or think about trademarking. So a unique business name might be wholly appropriate for you to seek to trademark, or your tagline, which is the next most common. If you are the holder of a trademark over a name or a phrase, you have exclusive use to that trademark. Think Coca-Cola, for example, or Cadbury chocolate. They have a trademark and they have exclusive use. When you don't have exclusive use, it means that somebody else can use the name. Registering your business name or your company name or your domain name for your website gives you the right to use that name. It does not give you exclusive use to that name. So for example, I have my business name, Tracy Milacrane Solicitor, registered because my company that runs my business, TM Solicitor Proprietary Limited, operates as Tracy Milacrane Solicitor. So I've registered that business name. I have my company name and I have my website URL. That doesn't give me exclusive use to the name Tracy Milacrane Solicitor or TM Solicitor. In fact, somebody else down the road, if they want to, can use, well, no one's going to want to use my name, are they? But they can use the TM Solicitor if they wanted to. And in the UK, in fact, I think that there is a law firm that trades as TM Solicitor in the UK, and for them it works. I don't have exclusive use to the name TM Solicitor. You in your business, with your URL or your company name or your business name, having those alone doesn't give you the exclusive use to the name. So the question is, do you need exclusive use to your business name or your tagline? Is there value attached to it? For people like myself, I would say no. I certainly don't need exclusive use to that. And in fact, if I tried to trademark TM Solicitor, I will be unsuccessful because the letters, the phrase TM Solicitor, it's not particularly unique, is it? It's very common and generic phrases or letters, and indeed the TM is the acronym for trademark. So people need to have the right to use TM and they need to have the right to use solicitor because it's descriptive, it says what I do. I can't trademark that even if I wanted to. The question is, do you need exclusive use? So if you are a business who thinks that there is real value in your business name, for example, take George Jensen, the jeweller, established in the early 1900s, and he has a very unique brand and design, and he has developed a lot of goodwill in that business. The way George is spelt in particular, and Jensen, that has goodwill, that has something very unique about it, and there is value in trademarking that in that particular industry. So that would have value. Coca-Cola, Pepsi, Cadbury, we can see the value. If your business is one where you see the value in trademarking your business name, your tagline, or your course name, for example, then it's something to consider. The trademark application is something to consider. But if you don't need the exclusive use, then there's no point embarking on this process. And that's what I advise my clients. It's not something that you go down for the sake of it. And we see it, it's very trendy at the moment, I think, to talk about trademarks and, let's trademark everything. It's not essential for every business owner to have to go down this path, which is why I'm talking about this today. If you do decide that it is for you and your business name or your tagline or your digital course or product really does need exclusive use of the name, then we embark on the trademark application process. It's not a straightforward tick-a-box exercise. There is some thought required because when you make your application for a trademark, you need to think about what class you're going to apply in. And there are lots of different classes. So it's not just a matter of popping along to the IP Australia website, popping in your name, hitting submit for your trademark application. It's more involved than that. And you need to give consideration to that because this is where it starts becoming a little costly. For each class that you seek to apply in, you need to pay a fee. The more classes, the higher the fee. And if you're successful, it gives you exclusive use to that name or phrase in that particular class. So for example, if you are successful in obtaining a trademark for your business name in a legal services industry, there is nothing stopping somebody selling confectionery and sweets seeking to use that name as well. It's a different class, and the test that is applied is whether or not members of the public or consumers are likely to be confused or indeed misled in relation to the use of the name. So somebody practicing a law firm calling it one thing and then someone selling confectionery down the road, it's unlikely to confuse consumers about what business they're operating in and what they're doing, what they're offering. Considering whether or not to apply for a trademark, in my view, is something that needs to be considered in the overall strategic objectives of the business as well. It is a lengthy process. It takes a while for this type of thing to be processed. So on average at the moment, from application to final determination or approval, a trademark's taking around 7.5 months. So it's not just something that we think, we'll quickly just slap in this application and get a result next week. It doesn't work like that. So it really does need to be considered in the context of the overall strategic objectives for the business, in my view, and that's where it adds the most value. So if you are thinking about a trademark for your business, for the name, the tagline, or some other phrase, first and foremost, give thought to whether or not you need exclusive use to that name or tagline. If you do, then think about whether or not you may be able to apply for a trademark. It's not stock standard. Just because you want it doesn't mean you can have it. And I've explained the example in relation to my business name, TM Solicitor. If you then form a view that you do need the exclusive use and you ought to be able to trademark, attention and care ought to be taken when preparing your trademark application. Knowing, of course, that you need to give careful consideration to the classes and that it is not a quick and speedy process. Finally, just want to quickly touch on this one because it does factor into decision making. If you are successful in your application for a trademark, you need to actually use that trademark. So if it's a business name or a tagline, you can't then change your mind and park it, put it on the shelf and not use it, but expect to be able to maintain your trademark. You need to be using it. Clients have been unaware of this when talking to me, thinking I'd like to trademark these 3 particular phrases just to stop somebody else in the industry using them because I might like to use it at some point. It doesn't work like that. Using it consistently is necessary to be able to hold on to your trademark because it does need to be renewed over a period of time. That is what I wanted to share with you in relation to trademarks and your decision-making process and thought process about whether to apply or not to apply. I hope it's been helpful in shedding some light and some context on the process and in just giving you some pointers on the types of things that you really ought to be thinking about when you're starting to think about whether or not a trademark is right for you and your business. As always, if you've got any questions or you want to talk a little bit more about anything that I've touched on, please feel free to reach out. That's what I'm here for. I'll catch you next time. That's it for today's episode. Short and sharp, just like I promised. If you liked the episode, please be sure to hit subscribe so you don't miss any new episodes, and I would be most grateful if you would leave a review on Apple Podcasts. As always, remember to keep your business legals in order with my annual legal checklist. You can grab your free copy by heading over to my website, tmsolicitor.com.au/checklist. I'll catch you next week. Thanks so much for listening.